in. We are going live from Las Vegas right now to talk about what to do during an NDA breach for your company. My name is Acacia Thornton. I'm the CEO Legal Coach, and this is for business owners and entrepreneurs. Today is not about what you need to know legally and all. No, today is about the action steps and what to expect so you can take quick, swift action to stepping up to protect your business. And I know that you're very busy and we are in the middle of your workday. So we're going to keep this short and simple to what you need to know in about 20 to 30 minutes. And then I'm going to open it up for live Q&A here on the spot where you can put your questions right into the chat and I will work to answer them. Now, my headphones are not working so well today, so I am in my electronic Princess Leia look. I hope you like it. But it does make things a little interesting, so I hope you all can hear me very well, and I am excited. So let's dive in, shall we? All right, what to do during an NDA breach. Now, today we are going to be talking about NDAs between businesses, usually a B2B situation. So between you and a supplier, you and a customer, maybe your freelancers, almost all of your situations except your employees. NDAs with employees are going to follow a similar parallel structure to what we'll talk about today, but there might be some nuances. So it's not going to be 100% directed towards that. But all of your business relationships where you have an NDA and you feel that there is an actual or threatened breach, today you're going to have what you need. So this initial talk, what are we going to talk about? We're going to give you just the basics on what's an NDA and a breach so you know what to look out for and what your rights are. And then we're going to talk about the 2 phases of action to take to get yourself remediated and recovered from whatever harm may be happening to you. And again, we're going to focus more on the action steps here more than anything about like what's in the document or this is the legal principles. Nah. You need to get to the heart of things. So that's what we're going to do. And then as mentioned, we're going to have that open Q&A. And I'm also going to give you a freebie, a free NDA template at the end of this that is customizable for your business and your relationships so that you know you're protected to help reduce anything that we're going to go through today. So what's the goal again? Take informed action quickly and confidently without losing the time of researching, avoiding, being distracted. When things go wrong with our business, we don't have time to put out fires, right? They are so distracting from revenue making activities that we don't want to have to go sit down, research something, sit down and go pay a legal fee, go sit down and deal with lawyers if we don't have to. So let's not. Let's avoid all of that now. Now, who am I? Why do I have any idea what I am talking about? I am the CEO Legal Coach, Acacia Thornton. I'm a licensed attorney for over a decade. I have been senior legal counsel to Fortune 500s. I've also worked with the Small Business Development Center, the Wells Fargo Center for Small Business. I am a business coach, a sales rep, and a business consultant for about 20 years of my career. But what really makes today's topic important to me personally is that I believe business owners have the right to protect their ideas and build their dream companies from day one. And NDAs are something that the big guys are doing every single day for free. And just because the little guys are newer, haven't seen that yet, or maybe feel a little insecure, uncertain, does not degrade the value of their ideas or what they're trying to build. So this is a topic that has personal value to me, and I'm a really big believer in getting everybody an NDA in their hands to use to protect all of that. Now, let's get into just those basics for a moment. What the heck is an NDA? NDA stands for non-disclosure agreement. Sometimes it's called a confidentiality agreement. It means the same thing. The goal here is to prohibit sharing of information that's non-public, but that needs to be shared. For example, you might need to share some things about your business, your products, how things work with potential customers or suppliers. But you don't want to be sending all that stuff out there for free to anybody. You don't want it in the hands of your competitors. You don't put it on your website for a reason. But sometimes you have to get a little intimate about what it takes to build those relationships based on the information you have for your company. So an NDA protects this from going further than you intend or being used in a way you did not intend. And then, of course, a breach of that means somebody violated the NDA, that agreement you had about not sharing stuff, with somebody that they weren't supposed to share it with, or that they used it in a way that you didn't give them permission for. You didn't give away your samples to your customers so that they may go build their own products to compete with you. No, you gave away your samples hoping that they'll come to you as customers. So there's this idea of who it's being shared with, but also the way it's being used. And then when we have a breach of a non-disclosure agreement, depending on the type of information that was involved in that, there might be intellectual property violations. We call these IP violations. So there might be trade secret sharing, copyright infringement, or other things involved that kind of bolster and booster both the harm to you, but also your ability to step up and take action. Now, one thing to know is that a lot of companies don't like using NDAs because they're like, I trust the people I'm doing business with. All of us do. Nobody wants to work with people we don't want to work with. We definitely wouldn't give our sensitive information to them. Majority of breaches of confidential terms, like an NDA, are usually accidental or unintentional. An example would be I had one with a client where somebody password shared. They were just sharing of a password since somebody was able to log into the system through somebody else's access. But that ended up meaning somebody who wasn't supposed to have a login now had access to information. And it caused a problem with upstream suppliers that ended up costing a lot of money and time over something as simple as a password share, which I'm sure was innocent and not meant to be anything bad. Same with just neglect or data breaches. Things like these happen. Maybe you accidentally leave something behind at the airport or a cafe. You didn't do it to be mean. You didn't do it to break a law. You didn't do it to be a breach of contract. This stuff happens. But when stuff happens, we still might experience harm. And so here's the two phases that you're going to go through to recover from that. Phase one that we're going to talk about here is you're going to stop the breach. Something is going on out there with your information that you did not put out there for that reason. You want it stopped. And then phase two is you're going to recover. We want you recovered, we want you reimbursed, and we want you to be able to return to normal business as usual. So phase number one, stop the breach. And there's going to be two steps you're going to take here to stop your breach. The first is sending out a cease and desist letter. Now, it doesn't have to be as formal as a cease and desist letter. It can be one that you send out yourself. And by the way, you do not need an attorney to send out a cease and desist letter. But the goal here is to inform the other side that a breach has or might be occurring, because the other side might not know. What if they had a disgruntled employee who left and took something with them? The company you're working with, the company that signed that NDA, they might not even be aware. So again, most breaches are not intentional. And so the first step is just to even make them aware so they could step up, take action to help you, because they don't want to be in breach either. They don't want to be responsible to the extent that they don't have to be. So they are now incentivized to help you stop what's going on. And then your second option under this stop the breach phase is to get an injunction from the court. Now, what is an injunction? An injunction is when the court literally says in a court order, other side, you've got to stop doing this. It puts the other side on notice and gives them a court order that they have to do or not do something based on what's causing the harm of your breach. Now, a little note on injunctions. Well, that sounds really awesome and really incredible, especially because you can get them pretty quickly, sometimes even within a day or two, is that the courts don't like giving these out. They don't like giving them out because they're stepping in without taking the time to know everything that's going on. We can't know the full extent of something in a day or two. The courts definitely can't. They don't know your business. They don't know the other side. They may not even know your industry. So they don't want to step in and require a company to do or not do something without that full assessment. So it becomes very important to be able to demonstrate in a way the courts are going to find convincing that you have an immediate risk of harm to your business. And so because of this, I'm going to strongly advise, if you do feel you need to take this level of action, that you get an attorney for this one. An attorney is going to know sort of how to convince the local courts to do this, but also what the standards are and how to get the right evidence at the right time to get you that court order, because you definitely don't want to go through the time and expense of this to not get your injunction. But do know that if you can prove that very quickly, you can get one of these very quickly, which will help you stop that breach. So the first phase is to stop the breach. Do whatever you can right now to stop it. Don't worry about assessing the harm. Of course, harm is happening. Why else would you be going through all of this? That's why you put the NDA there to begin with. But it could cause us to sort of chase our tail or find little fires along the way without ever getting to the core root of the problem. And the core root of the problem right now is that somebody is breaching, and we need to stop, plug that gap. And once we do that, then we can move into phase number 2, which is start getting you the full assessment of what has happened and how to recover from it. And so phase 2 is that recovery. And we're going to walk through kind of recover your lost revenue and how you can get the reimbursement for the costs and expenses that you have undergone in phase 1. You might have taken on a lot of stuff in phase 1, maybe had to hire out, get some help, bring in your employees to do something. Maybe your employees couldn't do other work because they had to stop and help you get things under control. Well, that is all time and money spent. So what are the parts of phase 2? Phase 2 also has 2 subpoints. Part 1, assess the damage, and step 2, get reimbursement. Now, let's take a moment here. Are you all finding this very helpful? I want to make sure that I'm getting to the points that are actionable for you in a quick way that is impactful for you. So do go ahead and give me a holler or a hell yes in the chat so I can see it. I love it. Oh, good. Okay, yes. Yes, if you do have questions, go ahead. We will be getting to those towards the end here. So save your questions. Absolutely. I can appreciate that hearing some of these kind of quickly might be bringing up new ideas and new thoughts. We'll get to them. Don't worry. I just want to get to the core points for everyone, but I'm glad you guys are loving this. All right. So phase 2, the action steps: assess the damage and then get reimbursement. And assessing the damage, you're going to want to look at a number of things here, right? Potentially there was a loss of revenue. Depending on what was leaked, who it was leaked to, and how far that leak got, there might have been a harm. You might have lost potential sales. You may have lost a potential product you were building. Maybe there's not going to be more competitors in the market than there were before because information is now out there, making it easier. Especially if the other side did anything like we said earlier, where they took your information and made a competing product, well, that's definitely going to have an impact to the loss of revenue. The expenses from phase 1. Again, it took you time and money to possibly write that cease and desist letter, send that out, find out what's going on. You might have had to sit down with your suppliers or other business relationships to tell them what's going on if you had contractual obligations to do so, because this is a potential type of breach of contract for you because of something somebody else did. And so all of this harm, all of this time and money spent, this matters. So go through all of those expenses that you went through and write them out. Same with that time and your manpower, right? Your time has a cost of business. You can kind of take this by what would be your salary at your hourly rate. Did you spend 80 hours on this? What is 80 hours of your time valued at? Same with anybody who helped you. Did you have to get your managers, your directors involved? Did you have to outsource anything to attorneys, audit companies, and so on? All of that matters here. And then, of course, just the general cost to return back to normal. Do you have to now go out and do a new marketing plan? Do you have to change how things are with your customers? Whatever it takes to get you back to normal is part of the damage that has occurred to your company because of this breach. So this first step in phase 2 is just to assess the damage and now know what it is, because you have stopped the breach successfully in phase 1. You now are able to have a proper sense and take a moment to breathe and get what this dollar and overall harm was to your company. And then now we're going to get you reimbursed for that. Yes. So there's a few different ways to get reimbursement. First, we already know that the other side has breached the contract. And especially if you have identified the correct source, that is really important, because nobody's going to want to take responsibility or pay fees for something that was not their fault or that they're going to argue against was their fault. But once you have assessed all of your damages and you can put them into a numerical form, you can now send a demand letter. And what a demand letter is a letter saying, hey, you breached the NDA terms that we had together. Here's how you breached them. Here's the harm that occurred and the dollar amount of that. And then, of course, when you send that demand letter, you always have the option of settling. Sometimes it is worth going a little less than what you're asking for in order to get payment quickly, because you do want to avoid the other side having too much time or opportunity to push back. If it's really only reasonable that $10,000 worth of damage happened, don't go asking for $1 million, because the other side's not going to want to pay $1 million. But if they do have the right types of insurance and other things, this might be a little easier for you to get a number much quicker. Also, if your NDA has indemnification, a lot of the NDAs these days don't have indemnification, but there's still about 20 to 30% of them out there that do. What indemnification is it says at contract, you're automatically going to reimburse me for the expenses that arise out of your breach. So you also have that provision, which is a little different than your damages. Damages are the harm that has occurred, where the costs are more about what we talked about in getting back to normal and those types of things. Indemnification is them already contractually agreeing to reimburse you. So when you remind them that they have an indemnification obligation, they're going to be more likely to cover those costs a lot faster as well, above and beyond just what the damages are. And then, of course, if you're unable to get their attention, or you're not getting what you want out of the settlement or the opportunities that they're offering to you, you do have the right to file a lawsuit, because they have breached an NDA, which is a contract. So there's a contractual breach, but also, as mentioned, the IP violations, right? If your trade secret is what got leaked, that's huge, especially if it was intentional. There's additional consequences and statutory fees that they now owe to you. There's penalties that they owe to you. They're also going to be required to cover your attorney's expenses if they did copyright infringement and things like that. So you might have multiple causes of action. And while you can always file a complaint with the courts yourself, of course, one with an attorney is always going to make that a little bit smoother and more impactful. But of course, before you spend that time and money, decide, looking at what you did in your first step of phase 2 here is, are the damages worth it? If you only had $10,000 worth of damages, is it worth paying a law firm $20,000 to do something at court for you? Probably not. So do know that you have that business decision to make here as well. The costs of the time to move forward and get recovery versus what the actual harm and loss was for you. So those are your 2 phases of action in the event you ever have a breach of an NDA, of your confidentiality terms and agreements. Phase 1, stop that breach as soon as you can. Use a cease and desist letter to inform the other side, because they may not be aware. If they are aware, you're putting them on notice that now you know too. And then, of course, if you need the courts to step in with an injunction, you can get one of those. Once your breach has been stopped, the gap has been plugged, you can now take the time to assess the total harm that has occurred, the damages, as well as the expenses that have arisen, and you can work to get reimbursed with a demand letter if you have indemnification in your NDA, and of course, the opportunity to file a lawsuit. Now, yes, so there we are. That's it. It really is that simple. 2 phases, each with 2 steps. And now we're going to open it up to Q&A. So as you guys start to go ahead and type into the chats, whatever your questions are, I'm going to get to them and answer them here on the spot to the best of my ability. But while you all do that, I do want to let you know NDAs are a big deal to me personally. I always give one away for free. So know that you have access to a free NDA template that you can customize for your business and your use case in under 10 minutes. I give you a video walking you through the 6 steps to do that for free. I'm also going to give you a video reading that template to you, because I would never have you use or sign anything that you haven't read. So I'm going to read it to you in a totally awesome, exciting way that every contract should be read in. I know you guys are loving that too, right? But I also want you to feel comfortable and confident in using an NDA. So you're going to get step-by-step videos, including talk tracks. How do you ask a customer to sign an NDA? You're going to get talk tracks word for word on how to do that. You're going to know what to expect after an NDA is signed, and so much more. I'm going to walk you through everything, and this is all included for free with this NDA template. And do know that you can find that at my website, CEOLegalcoach.com/free NDA templates. That's CEOLegalcoach.com/free NDA templates. And that's where you're going to find all of that information. Just plug in your email and everything else will just automatically populate for you. And you'll have endless access to that. You'll also get an email with all the resources so you can quickly find it. Now, are you guys ready for Q&A? All right, let's see what the kind of stuff you guys came up with. What do we have here? Okay. All right, okay, yeah, okay, I like this one. Okay. What are the types of breaches that you can have with an NDA? So as mentioned, right, we have the breach of the contract itself. So whatever terms are in there. And it could be a breach of using it the way they weren't supposed to use it. It could be a breach of sharing it with somebody they weren't supposed to share it with, or just having access to it by somebody who wasn't supposed to have access. So we have that type of breach right there. That's a straight violation of the contract. But then you can also have the other things like the IP, right? If somebody's copying your copyrighted work, well, that's a violation of copyright law. With or without a contract, that's a violation of copyright law. If somebody's taking your trade secrets and doing something they're not supposed to do with your trade secrets, that's a violation of trade secret law with or without a contract. What's great about the NDA is it's already put them on notice that this stuff is confidential. So you have that other layer really supporting and bolstering the idea of a different type of thing. Now, IP is usually the other way that a breach might occur, or the lawsuit type of action you would have. It doesn't mean it's the only one. It's always going to come down to the type of information being shared, who it was shared with, and how it was being used. So there might be additional ones, but those are the most common with an NDA. Yeah, great question. What do we have here? Let's see. How do you prevent future breaches? Okay. All right. A few things here. All right. Let me see if I can think of this. First is knowing that every time you share your information is a risk. And the more times you share your information, the more that risk compounds. So while you might trust everybody individually, once you get it away 20 times, there's 20 different risks. And again, as mentioned earlier, breaches are rarely intentional, right? They're usually accidental. So now you have 20 different people or companies that could accidentally do something, and every one of those has a compounding harm, because it's not about the dollar amount of the value of the potential contract, right? A $100 customer could cause you just as much pain as your $10,000 customer if they leak the same information to the wrong people. So it's really important to only share, getting to the core of the question here, like how do you prevent the breach, is knowing who the other side is as a company, not just the person you're dealing with, but as a company. Do they have policies in place? Do they have procedures in place? Do they have good data security? Do they have good privacy? Based on the type of information you're sharing with them, how reliable are they as a company in their setup and their processes to take care of your confidential information? And then making sure that what you're sharing as you're sharing it is informing them, is this confidential? Right? By the time you've been in a business relationship for a few months, even a few years, maybe you're out to dinner, maybe you're out to lunch, you're having cocktails and talking with a bunch of people, you start to forget that what's being shared might be confidential or classified, protected information. And so reminding them, like, hey, what we're going to talk about here, we got to keep this on the down low. This is confidential information. And when you send something, put it in your emails. This is confidential. Mark your documents. This is confidential. I automatically do on almost all my documents when I work with my employees and freelancers, as I say at the very top as I create a document, confidential, not allowed to go out. And of course, everyone I work with always signs an NDA. So I have an NDA in place. I am informing them and reminding them along the way of the relationship that what I'm sharing is confidential. The other thing is don't share more than you need to. right? I might have a 5-page document, but if they only need to see 2 paragraphs of that, that's 4.5 pages of confidential information going out the door that doesn't need to. And like I had mentioned before, the more we share it, the more we put it out there, especially the less valuable it is to the other side, the less likely they are to protect it. Or if it's more than they intended to see, they might start secretly having things that they're like, whoa, so-and-so just shared that with us? Look what we now have in front of us. And it could be very difficult to fight the human nature to not take advantage of what's in front of us. It really is. We don't want to do something that's mean or bad, but we do want to take advantage of the opportunities and the resources in front of us. So just don't give them the chance. Take responsibility for your information, how you're sharing it, and how often you're notifying the other side of the friendly reminders like, hey, we got to keep this on the down low. This is not public information. So do keep it that way. So those types of things are a great way to help reduce the risks of a breach. Okay, what else we got? How do you prove a breach? Yeah. This can be a fun one because sometimes as entrepreneurs, we have to make gut decisions. The good news is that when it comes to stopping the potential breach, like we talked about in phase 1, is there doesn't have to be an actual breach yet. There could just be a threatened one because we're not asking for damages or anything yet. But we do want to be mindful of how we're communicating when somebody has done something versus when they haven't yet. But just saying, hey, we think there might be something going on here. And you have that cease and desist letter to them or just a cordial email and some type of notification to them to put them on notice. But how do you really know when so much of that is behind the scenes? And this is where proving a breach can be a little difficult. When it comes to proving a breach, there does need to be a connection to the information you gave them and where the breach has occurred. And I mean that in the sense of, let's say they gave it to your competitor. So you gave a potential customer your information under an NDA on, let's say, May 1st. And then suddenly on May 30th, your competitor has something for that customer that's almost word for word what you had given the customer. That's coincidental evidence. And that enough of that type of evidence can suggest or start to point to, hey, there might have been a breach here. And the more circumstantial the evidence we can do, the better. So of course, we would all love to have the smoking gun of, haha, I have the video of you giving them our document and they're doing this with it. That would be lovely to have. But it rarely happens that cleanly. But sometimes they do. Sometimes just post something on the internet, like social media posts. Or like, we're so excited to announce that we're doing this. And you're just like, oh my gosh, guys. You're like, so it can be that clear and obvious, but usually it's a little bit behind the scenes where we have to take a little bit more of a gut reaction. And so instead of just going with our emotions, trying to actually stop and see what is the evidence that would be convincing to a third party. And because it usually would be an arbitrator or the courts or somebody else that we have to convince this harm did in fact happen. And so having whatever we can to do that would be really helpful. And so circumstantial evidence, testimony does help. And anything that you could have tangible things on, like a screenshot, a video, an audio recording, documents, proof that you sent them something in an email and it shows up here in this way. Like those types of connecting those dots are going to be really helpful for anyone out there. So any evidence that supports that, even if it's piece by piece, right? Sometimes you need A plus B to equal C. That's okay too. That's usually how you would end up proving a breach, is that connection to the information you shared, something about it being in their hands, and then something tangible to them or ancillary to them and their relationships, demonstrating how it got out beyond its intended to reach your purpose. Yeah. Oh, you guys have some good questions. Okay, let's see. What constitutes a breach? So it'll always come down to the specific terms of your NDA, but the crux of every NDA is, I'm giving you this information. This is confidential, meaning it's not public, It's not supposed to be public. You may only share it with these people, and you may only use it in this way. So, if anything that was defined as confidential information on your NDA was given to somebody that it shouldn't have been, or was used in a way, whether that it shouldn't have been, whether that was by somebody who had permission to have it, even somebody who has permission to have it, they use it in a way they're not supposed to. If these things were clear on the NDA of who they can and can't share it with, or what they can and cannot do with it, anything they do outside of that is a breach of the NDA or your terms of confidentiality. Yep. All right, I am thinking one more. Did I get everything? Okay. Can I go through the consequences of breaching an NDA? Okay, sure. So consequences can fall in a few different ways: monetary, reputational harm, even criminal harm. Ouch. So the first is whenever there is a breach of a contract, there's what we call direct or indirect damages. Direct damages are things that were directly caused by a breach of this contract. You broke it, here is exactly what happened. And then indirect is kind of the fallout, what sort of happens that, but for you breaking this and causing these damages, these other things wouldn't have happened. And depending on the terms of the contract and what you can prove at court and so on, based on your reimbursement recovery options that you decide to take, all of that could be consequences the other side is responsible for. But it doesn't just stop there. If it's in your NDA, which oftentimes in most contracts it is, they also are responsible for paying your legal fees. And if they've violated your IP in any way, under statute, they are required to pay for your legal fees. So you're not just paying for, they just have to pay for their lawyers, they have to pay for yours too. And your lawyers, your court fees, all of that stuff is going to be on their responsibility to reimburse you for that. So we have further, which isn't a direct damage, that's just something that comes out of litigating or processing this. Criminal. It is not illegal at criminal law to violate or breach a contract. However, there are certain intellectual property laws that if you intentionally violate them, or other types of corporate laws that if you intentionally violate them, it is a criminal violation. An example is trade secrets. If you knowingly and intentionally give out somebody else's trade secret, you could personally be criminally responsible. So that's not listed directly in the NDA because there's already a law that says that. Everything that is in a contract is above and beyond what's required at the bare minimum of law. So if there's already a law that says this is illegal, then that also applies. And for trade secrets, definitely criminal penalties could apply. And then, of course, you have other things like if you collude or antitrust, just like other things that can come into play. I know environmental law sometimes have criminal stuff. So depending on what was involved, what steps were taken, and so on, it could lead to criminal stuff, although less likely in the NDA context outside of IP, but never impossible. There's always a case that will surprise you. The other things that could be happening is it's not just monetary, right? Now you're the person who breaches NDAs. You might end up with bad press against you, especially if a lawsuit is filed, because lawsuits are public awareness, so the media might pick it up. But you're also, the other side might start telling people, these people breach NDAs. They're not a trustworthy company. So in addition to having the monetary harm, which might cause bankruptcy or something else, or the risk of personally being criminally liable, but your reputation's on the harm, on the line. Do you want to be that person? Do you want to be that company? Most of the time, no. Now, again, if there's accidental stuff, this stuff doesn't usually go as far. But if there's intentionality to that, or there's a really big impact, like there's a true data breach, right? We all know about the Yahoo data breaches, the Target data breaches, the Home Depot data breaches, right? Data breaches are a big deal right now, regardless of what was or was not accessed, right? Sometimes it's just your name and your address. You can get that out of a phone book, but yet the reputational harm through the media and other things comes along and can really cause damage in other ways. So breaching an NDA accidentally or intentionally is not just about monetary damages and covering attorney's fees. it could put your reputation as a person and as a company on the line in ways that you don't want to deal with it. Yeah. So, all right. Is that everyone's questions? Do we have any others? Okay. I love it. I love it. I love it. We got through that 35 minutes. Totally friggin' awesome. Thank you. Thank you all. Do you know if you have any further questions, you could always reach me through my website, CEOLegalcoach.com. This is Acacia. You guys, I love you. Stay awesome out there. Keep kicking